Welcome to Global Dispatches, a podcast about world affairs and the people who shape it. I'm your host, Mark Leon Goldberg, editor of UN Dispatch, and in this show we discuss topical global issues and have in-depth conversations with personalities in foreign policy. Global Dispatches is presented in partnership with Humanity in Action, an international educational organization, and I am a Humanity in Action Senior Fellow. A case that is pending before the Supreme Court of the United States could have profound implications for human rights and corporate social responsibility around the world. The case is called Gessner versus Arab Bank. It's a lawsuit in which the plaintiffs allege that Arab Bank, which is a Jordanian financial institution, facilitated payments to terrorist groups that carried out attacks in Israel, killing and injuring them. Now, a case involving foreign victims of a terrorist attack carried out on foreign soil by a foreign group would not typically be the business of the U.S. legal system. But the plaintiffs in this case are pursuing damages using a law that has been on the books since the 18th century called the Alien Tort Statute. And according to my guest today, Dr. Zachary Kaufman, if the Supreme Court rules in favor of the plaintiffs, this statute could influence corporate decision-making and even U.S. foreign policy for years to come. Zachary Kaufman is a senior fellow at the Harvard Kennedy School of Government and is teaching at Stanford Law School. He is also, like me, a Humanity in Action senior fellow. So, of course, this is a great opportunity to plug the Humanity in Action Fellowship Program. Applications are open for the next summer fellowship program. Go to globaldispatchespodcast.com and you'll find a link to the application there. And if you have any questions about Humanity in Action, do send me an email. You can use the globaldispatchespodcast.com homepage contact button. I'm happy to steer you in the right direction. Okay, now here is my conversation with Dr. Zachary Kaufman.
These are survivors of terrorist attacks in Israel and the Palestinian territories, as well as relatives of some of the deceased from these terrorist attacks. So this plaintiff group is suing Arab Bank under the Alien Tort Statute. And the Alien Tort Statute is a very old statute of the United States that says that the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States.
And this goes back to like the 18th century, right? This is.
It does. It's an extremely early statute in the U.S. In many ways, over the last several decades, has kind of been rediscovered in a way and applied to various cases. And so the matter before the Supreme Court in this case is that the plaintiffs are suing a bank called Arab Bank, which is headquartered in Jordan, but also has branches around the world, including one in New York City. And so the plaintiffs are alleging that Arab Bank knowingly financed and facilitated the terrorist attacks that they suffered, and so they should properly be sued or could be sued. And so the question before the court is whether the Alien Tort Statute would permit corporate liability under its terms.
And the Alien Tort Statute is a vehicle that human rights groups in the past have used to press for claims against human rights violations that have occurred outside of the United States. Is that right?
Exactly. And so along the way, the courts have been trying to assess which of those types of claims are legally permissible, which of these suits can actually proceed. And in Kiobel, a previous case before the Supreme Court, the court decided that when a petitioner group or an individual petitioner wants to assert an Alien Tort Statute claim, the claim needs to touch and concern. So there needs to be a nexus that's sufficiently close as to permit such a claim. And so That's one of the issues that the court is trying to assess in this case.
Like there has to be like an American connection to this human rights violation that occurred abroad.
That's right. And specifically under Kiobel, the touch and concern has to be, quote, with sufficient force to displace the presumption, end quote, against extraterritoriality. And so the presumption against extraterritoriality basically is a shorthand way of saying that situations that are not sufficiently close in connection to the United States are presumptively outside the jurisdiction of our court system.
So in Gessner versus Arab Bank, the victims are I suppose it's families of victims or victims of terrorist attacks and survivors are claiming that Arab Bank was used to finance the terrorist activities that funded the attacks that injured them. Is that right?
That's right. The allegation is that that Arab Bank used its New York branch to collect donations, to transfer money, and also to serve as a sort of paymaster for terrorists, and that the bank was distributing U.S. dollar payments in the millions to finance suicide bombings and to make what are often known as martyrdom payments, which are payments rewarding families of terrorists for killing innocent civilians. So there's this allegation that Arab Bank knew what it was doing and that the New York branch of it was involved in that process.
So why does this case have such important and profound implications for both U.S. foreign policy on the one hand, but also corporate social responsibility on the other?
So I'll start with corporate social responsibility. Arab Bank, in addition to lots of other companies, of course, like to boast or claim their corporate social responsibility to their local, national, perhaps even the international community. And basically, they suggest that they are responsible members and perform their services in a socially, sometimes even environmentally conscious fashion. And so, most of those CSR, corporate social responsibility activities are, they're purely voluntary. And they, of course, have reputational consequences if they're violated. But what this would do, what this case, if it were to proceed in a ruling against Arab Bank, is to also perhaps even make legal or make required through law a certain type of corporate social responsibility. So this is profound. This case has profound significance, potentially at least, for corporate social responsibility, even of corporations that are headquartered outside the United States, as Arab Bank is.
Well, just to follow that thread a little bit. So if the Supreme Court rules against Arab Bank, the idea is that it would imply that corporations around the world have certain sets of responsibilities they must uphold for fear of being sued in American courts?
That's correct, if they could satisfy the touch and concern test under Kiobel. So it wouldn't just be any corporation. It would be a corporation that has a sufficient nexus to the United States such that the jurisdiction could be asserted in the case.
Like, what are some possible scenarios regarding like how a company might need to change its behavior if it does have that kind of touch and concern, if it satisfies that touch and concern threshold?
Well, in the case at hand, Gessner versus Arab Bank, the allegation from the petitioners is that the bank knowingly was financing and facilitating terrorism. So, one consequence of this case, if a ruling was made against Arab Bank, is that financial institutions could not, at least knowingly, finance and facilitate terrorism. And if you did, if such a financial institution did, it could be held civilly liable under a ruling against Arab Bank, in this case, as a precedent, for substantial sums of money.
And so on the second part of the question on how this ruling may affect U.S. foreign policy more broadly. I mean, what's your analysis? Like, how if the ruling is in favor of Gessner, how would sort of U.S. foreign policy be affected in any meaningful way?
The U.S. government submitted an amicus brief in Gessner versus Arab Bank, and it talks about its foreign policy interests in the case. It talks about how it has a close relationship with Jordan, which is where Arab Bank is headquartered, and Arab Bank is the largest financial institution in that country. And it also talks about its ongoing cooperation with Arab Bank itself in combating terrorist financing. So there are different ways of sort of looking at the foreign policy issue. There might be ways that the foreign policy interests of the United States could be harmed, and this is what the amicus brief that the U.S. government submitted claims. If such a case proceeded against Arab Bank, for example, as the U.S. government argues, its relationship with Jordan and with Arab Bank could both be harmed, and therefore the U.S. government's ability to cooperate with Jordan, which is it asserts as a close ally in combating terrorism, that would suffer, and also its relationship with Arab Bank would suffer. Now, if we are to believe the plaintiffs, though, then Jordan, or at least Arab Bank, have not been sufficiently rigorous in their combating of terrorist financing through Arab Bank. And if indeed Arab Bank knowingly facilitated and financed terrorism, then they were actually complicit and fully cooperative. And that would cut against the U.S. government's claim that Arab Bank is such a cooperative, sincerely, cooperative partner in combating terrorism and terrorist financing. So, on the one hand, the U.S. government argues that certain of its relationships could suffer, and that would be detrimental to combating terrorism. But on the other hand, I would assert that if the case were to proceed and Arab Bank were held accountable, and if it is true that it knowingly did finance and facilitate terrorism, then I would argue that this case could actually help promote combating of terrorist financing and therefore terrorism around the world, which is in the interest, of course, of the U.S. government, even though this particular case doesn't involve Americans. Americans, of course, are targeted around the world in terrorism, and terrorism, of course, is used against the United States on our soil. And so the precedent of this case, if it were to be resolved against Arab Bank, could actually be used in the U.S. government's favor to protect American citizens abroad or at home, and also to combat terrorist financing worldwide.
Is the amicus brief that was filed by the Trump administration, I mean, something that you could also see coming from the Obama administration, as in there's not much sort of ideological about it so much as wanting to uphold the ability of the White House and the executive branch of just conducting foreign policy on its own terms?
Former Obama administration officials have also filed an amicus brief, and they argue that the foreign policy and national security interests of the U.S. government could indeed be promoted if this case were ruled against Arab Bank
for reasons you just articulated, probably.
That's exactly right. So I can't speak for the entire, I can't speak to the entire Obama administration, but I think that the amicus brief that certain national security officials who served in the Obama administration have presented in a brief they also have filed. I think that could represent some of the views of or does represent some of the views of former Obama administration officials.
So I'm not going to ask you to like predict the outcome of this ruling, but I mean, in general, do questions about the Alien Tort Statute sort of divide themselves along the kinds of ideological lines that we've become accustomed to on the Supreme Court between like the originalists on the one hand and the liberals on the other hand?
I think the ideological line isn't so much sort of conservative and liberal or originalist. I think it's more about you know, first of all, the text of the Aliens Tort Statute is very sparse. It's a very short amount of sentence, and the uh, the meaning of the text, is has been battled in courts and in limitless law review articles, and even though it's a few hundred years old, we're still trying to figure out its full meaning and application. And certainly you're correct that there is traditionally a divide between conservatives and progressives on protecting the operations of corporations and not encroaching upon their activities as much. And that may certainly be animating some of the opposition to applying the Alien Tort Statute to corporations to find civil liability. But there's also just sort of a general, confusion still, I think, about what really the Alien Tort Statute claims, and people are spilling tons of ink over this issue now, and hopefully the case will bring some clarity.
Well, it also seems from like a political standpoint. I mean, this is a very clarifying case as well, because you have like what would be in an American domestic political context, a very sympathetic plaintiff, victims of terrorist attacks in Israel, versus like a big corporation. Whereas like in other sort of political contexts, you could have like, some random, lefty group versus like a big corporation might not inspire the same sort of sympathy to the extent that Supreme Court justices are swayed by these kinds of political considerations.
That's right. It is a very sympathetic group of plaintiffs. I mean, people have died. People were killed because of the activities that, if the plaintiff's accusations are correct, were facilitated by Air Bank. And so it is a very sympathetic case, and that's part of the reason that this case is drawing so much attention. I should also say that it's possible that the case will not be resolved on the merits. It's entirely possible that the Supreme Court may remand the case back down to have some sort of a determination over the jurisdictional question of whether the petitioner's claims in this case even satisfy the touch of concern standard that was identified in Kiobel. So, as we've been discussing, the connection to the United States is through the New York City branch, the Manhattan branch of this bank, but the terrorism itself, the victims, the perpetrators were all outside the United States. And so it could very well be the case that the Supreme Court decides that just more needs to be determined by a lower court as to whether the jurisdiction is even satisfied in this matter.
And that's just one of the reasons why I've always been fascinated by the Alien Tort Statute as a vehicle for, advancing or pursuing claims against human rights violations committed abroad. I mean, it seems like it's not perfect, but it's the closest thing the United States has to a kind of universal jurisdiction, which, other governments sometimes claim, but this is kind of the closest we seem to have toward it.
That's right. And, when we're talking about universal jurisdiction, we should also, of course, remember that the U.S. has had a real hostility towards that principle. Of course, the U.S. is sort of uniquely positioned in having so many troops stationed around the world and so many enemies in the world. And there have been various allegations, over time that the U.S. has that the U.S. itself has committed human rights violations, and so some countries and some plaintiffs, outside the country have asserted, claims against the United States, and the U.S. of course has tried to protect itself from having any liability, either through its civilian leaders or through its military, and so generally has opposed anything that any efforts that could bring Americans under universal jurisdiction, and this also animates part of the U.S. government's hostility towards the International Criminal Court. That the idea that Americans might be subject to the jurisdiction of this independent court.
Well, Zach, this is fascinating, and I appreciate your thoughts.
Thank you very much, Mark.
All right. Thank you all for listening. Thank you to Zach for taking time to speak with me, sharing some of his insights. I've known Zach for a while, so I knew this was going to be an interesting conversation. We actually had set out to talk about something else, but I saw just before I set up this interview that he had written about this case, which seemed really interesting to me. I knew a little bit about the Alien Tort Statute, how it had been used over the years as a vehicle in which domestic American groups pressed for claims against human rights abuses that occurred abroad. I saw that he had written on it. I did not know about this specific case, so I was glad to learn about it and learn more about what its broader implications are for U.S. foreign policy. So big thank you to Zach for speaking with me on this, basically on the fly. All right, we'll see you next time. Thanks. Bye.
The views and opinions expressed in the podcast are those of the speakers and do not necessarily reflect the policies or positions of Humanity in Action.